Enough is enough, said the Chief Justice of India, irked at the repeated petitions regarding Places of Worship Act. However, later, he asserted that new petitions will be allowed if it brings on something new. Chief Justice of India Sanjiv Khanna also noted that Centre has not filed a response yet and new petitions raising new grounds have come up. We are constrained to pass this order with the number of interventions filed, the top justice said. Meanwhile, the court dismissed writ petitions in which notice has not been issued. Quote, pending writ petitions, which has no notice to stands dismissed with liberty to file application raising additional grounds, unquote, which means CJI has allowed application for fresh interventions, given it will raise some new ground which has not been mentioned earlier. Earlier in the day, he had said, enough is enough, we are not going to entertain fresh petitions in the Places of Worship Act matter. CJI Khanna added on several petitions being moved in the Places of Worship Act matter that ever since the top court tagged all the matters pertaining to the question of validity of Places of Worship Act, several petitions have been filed in the top court. While earlier petitions in Supreme Court was filed by Ashwini Kumar Upadhyay, later the top court tagged all matters related to the temple-mosque disputes, including the Shahi-Idgah Krishna Janmbhoomi matter, Kashi Vishwanath Gyanvapi mosque dispute, Sambhal mosque dispute, Kamal Maula mosque and Saraswati temple dispute, etc. Following this, political parties including Congress and Asaduddin Owaisi also moved the top court in favor of the Places of Worship Act, while on the other hand, pleas were also filed by Hindu right-wing organizations challenging the validity of the act itself. In December of 2024, the Supreme Court had barred courts from registering fresh cases challenging the ownership of places of worship or ordering surveys to establish their character and identity until further notice. It had also paused any ongoing surveys as well. This came after it began hearing petitions challenging certain provisions of the Places of Worship Act. Among the 6 petitions facing the court that month was one by BJP's Subramaniam Swamy. The main petition was filed 4 years ago, to which the government was told to respond, but it never did. On the other side, certain petitions sought enforcement of this act, which prohibits filing a lawsuit to reclaim a place of worship or seek a change in character that prevailed on August 15, 1947. The order brought relief for petitioners in other cases as well, many of whom had sought to question the court-ordered surveys of mosques on claims that they were built over demolished Hindu temples hundreds of years ago. And the lower courts were directed to not pass any order or hear any new cases. In January of this year, Congress filed an intervention petition in the Supreme Court, which last month began hearing petitions challenging certain provisions of the Places of Worship Act 1991. The party has sought strict implementation of the law and also joined other opposition parties in moving the top court in this matter. Earlier this month, the top court agreed to hear Mr. Owaisi's plea, ordering it to be heard with others today. The law, introduced in 1991, prohibits converting or altering the character of any place of worship and prevents courts from entertaining disputes over its status, with the exception of the Babri Masjid Ram Janmbhoomi dispute, which was explicitly exempted. The Ram Janmbhoomi dispute had been a rallying cry of the Bharatiya Janata Party for decades. The court's decision on Places of Worship Act will impact the ongoing disputes pertaining to Krishna Janmbhoomi, Shahi-Idgah in Mathura, Gyanvapi and Kashi Vishwanath Temple in Varanasi.